Hello friends, in the series on the income tax cases, today we will discuss the case of Commissioner of Income Tax International Taxation versus Air India Limited. This case has been reported in 456 ITR at page number 139. The matter has been decided by Supreme Court and the date of the judgment is 4th July 2023. This case is related to section 206 AA, which says that in the case of payment which are eligible, on which the TDS is to be deducted and the payee does not have the PAN number, then in those cases the TDS is to be deducted at higher rate, that is generally 20%. In this case, the assessee was hiring the engine of the aircrafts from a non-resident company from Netherlands. The payee was related to Netherlands, so the double taxation avoidance agreement between India and Netherlands was prevailing. According to the Article 12, Sub-Article 4 of the double taxation avoidance agreement between India and Netherlands, the assessee has to deduct TDS on the rent which is to be paid for the hiring of the engines of the aircrafts. So the assessee deducted the TDS at the rate of 10% and make the payment to the payee accordingly. The non-resident payee does not have permanent establishment in this case, and the non-resident payee was not having the PAN number. When the learned assessing officer was making the assessment, it was the viewpoint of the learned assessing officer that since the payee does not have the PAN number, so the TDS should be deducted according to section 206 AA at the rate of 20%. It was the point of the assessee that in this case the payee was not required to obtain the PAN number, so section 206 AA does not apply. And moreover, when there is a conflict between the Income Tax Act and the double taxation avoidance agreement between any country, then it is a settled law that the provisions of double taxation avoidance agreement will prevail. When this matter was before the Honorable Delhi High Court, the Delhi High Court said that there is no doubt that the aircraft engine is the part of the aircraft, but it cannot be termed as aircraft, and it comes into the definition of the equipment, and according to the Article 12 Sub-Article 4 of the double taxation avoidance agreement between India and Netherlands, TDS at the rate of 10% is to be deducted for the rent paid for the equipment. But the learned assessing officer created the demand, and the Delhi High Court gave the relief to the assessee by saying that in this case section 206 AA will not prevail and double taxation avoidance agreement will prevail, and the assessee is justified in deducting the TDS at the rate of 10%, and there was no need to deduct the TDS at the rate of 20%. The matter moved to the Supreme Court. The Supreme Court also upheld the order of the Delhi High Court that in this case the double taxation avoidance agreement will prevail over the 206 AA provision of the Income Tax Act. Friends, this is very interesting case because at the face it appears that when the payee does not have the PAN number, so the TDS is to be deducted at the higher rate, but the rule of law which says that if there is any conflict between the provisions of the double taxation avoidance agreement and the Income Tax Act, then in those cases double taxation avoidance agreement will prevail. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax International Taxation versus Air India Limited. and this case has been reported in 456 ITR at page number 139. The matter has been decided by Supreme Court and the date of the judgment is 4th July 2023. Thank you, friends.